Mediation laws vary by state. First of all, who can mediate your case, whether a non-attorney or an attorney can serve as a mediator, as well as the training of the mediators vary by state, and of course the laws within the jurisdiction vary. We have mediators across the country that can help you both pre-divorce and mediating settlement of your entire divorce, as well as post-divorce. You're divorced and there's some issues that are bubbling up and you still have emotional and financial scars from your divorce process to begin with. You can work with one of our mediators to make a tweak to an agreement you presently have in place. Is your mediation agreement legally binding? It depends on how you entered the mediation and the term sheet that you reach at the end. You can have either a binding mediated settlement or non-binding. Most of our clients want binding mediation, meaning the terms that you reached in mediation, you are both contractually bound by those agreements, absent something unconscionable. And a mediator is not going to allow you to agree to something that's either illegal or unconscionable. But outside of those two areas, mediated settlements are binding in court. You and your spouse are living in separate jurisdictions, and your question is, can we still mediate our dispute? You absolutely can, but which law is binding? It's the law in the jurisdiction where you last lived as a couple. So I'm living in New Jersey, we start the process to divorce, my spouse moves to California, we can still mediate, but it's going to be New Jersey law that's governing that dispute. So in that scenario, you're going to hire a mediator in the state of New Jersey because it's New Jersey law that's governing, even though your spouse is in California. The same would hold true even if you have assets that are outside of the state. So staying in this same scenario, we live together in New Jersey, we have property in New Jersey. My spouse has now moved to California, purchased property in California. My mediator is going to be in the state of New Jersey, and my mediator is going to resolve all of the disputes between us, even the property that's outside of the state of New Jersey. We're going to look at all of our assets in total, irrespective of what state or even country the assets are sitting in. We're going to resolve all of that dispute in the home state in which we lived at the time we separated. Does it matter what county my mediator is in versus where I live? So do you have to get a mediator in the county that you live? Absolutely not. But you want a mediator that's familiar with how the judges in the county where you live rule. Why? You're going to say, I'm going to mediation. What difference does it make what a judge would do? It makes all the difference in the world, because as you're negotiating this settlement, you want to know the what if. What if we went into court? What would this look like? Now, your mediator doesn't have a crystal ball and can't predict with absolute certainty what a judge in your county would do, but it certainly helps the conversation to know, if I went into court, is my settlement position something close to what a judge would rule on? Or am I so far off out in left field that a judge would never rule in my favor? It really does help frame the conversation. Does jurisdiction matter in your mediation? Of course it does. You want a mediator that's familiar with the laws in the jurisdiction in which your case would have been filed. And county by county, while the laws don't change, you certainly want a mediator that has perspective on how the judges in the county in which your case would be filed rule. So if you want to learn more, contact our office. We could walk you through all your jurisdictional questions in a mediation.